So on behalf of the campus, I do welcome all of you to this 34th edition of the Archives Public Lecture Series. The Archives at NCBS, which is hosting the series, is a Center for the History of Contemporary Biology in India. However, the series that we run, which is actually coming up on 3 years this month, is a series to try and have eminent speakers from a variety of different disciplines come and talk about their work. And we've had academics, artists, lawyers, teachers, scientists, and many other different disciplines come and have a discussion with us. For more, I will share those details with you into the chat window about the series. So as you might have guessed, we've been running this series online on this Zoom platform since, for many months now. And we've kind of taken it for granted, this sort of, just running things on the web. But for a few months, we've been thinking a little bit about this question of, how easy it is to take the internet for granted in most urban spaces, and especially so during the pandemic, where pretty much everything is online, remote conference, online Zoom platform, this and that. And so we thought it would be really nice. And so we're really privileged to have Ashwin Mathew and Apar Gupta here to give us some context around, what is this thing that we call the internet? Or as it was in Ashwin's thesis, where in the world is the internet? So without further ado, I will go ahead and introduce the two speakers for today. Dr. Ashwin Mathew is an ethnographer of internet infrastructure and lecturer in global digital cultures in the Department of Digital Humanities at King's College in London. And Apar Gupta is a lawyer and the executive director of the Internet Freedom Foundation, which works on a range of issues, including net neutrality, free expression, privacy, and innovation. There is so much more that we could talk about both of their work, but at their request, we've decided to go ahead and put it into the chat window where you can read the larger description of their work and their biographies. The way we will structure today's conversation is Ashwin will first start off the discussion, giving us some broader context, and then we'll have Apar follow him. And after that, we'll have a question and answer session between them and also with the audience. So with that said, Ashwin, over to you. Thank you so much for being here.
Thanks very much for the welcome, Venkat. It's a privilege to be here today, and thank you to everyone who's tuned in. I'm looking forward to the conversation with Apar and also to hear what all of you think about this work. So let me get started. Okay. So the talk that I've made today, I'm calling Freedom and Control in Internet Infrastructure. You were promised a session talking about rights. And often we think about the internet nowadays as a right, so that we have a right to access the internet, that it's an integral part of our lives, and that everyone should have a right to the internet. But the question that I'd like to raise is, often we think of those rights as sets of laws and sets of things that are assured to us through governments, through international activity, and so on. But what I'd like us to think about is how those rights are assured through very material forms of infrastructure, and how ideas of freedom and control in the very infrastructure of the internet actually affect the way that we receive those rights and the way that those rights get constructed. Now, the way we often think about the internet, is as the cloud, and this is a common metaphor, and we call it the cloud because it's so hard to locate. Right? I think Venkat referred to my dissertation of several years ago, which was where in the world is the internet, because it really is so hard to find it. But when we do find it, it's often in the form of social media. For most people, this is the internet. It is WhatsApp, it's Facebook, it's YouTube, it's Twitter. And when we say the internet, that's really what we're referring to. But why do we think of these as being some kind of inherent good, some kind of right that we must have, the access to these things? Now, in the early days of the internet, there was a vision of the internet as intrinsically being something that provided freedom. And John Perry Barlow in 1996, in a seminal piece that is well worth reading in full if you'd like to look at it, he wrote this piece called A Declaration of the Independence of Cyberspace, and it opens, "Governments of the industrial world, you weary giants of flesh and steel, I come from cyberspace, the new home of mind. On behalf of the future, I ask you of the past to leave us alone. You're not welcome among us. You have no sovereignty where we gather. And indeed, when we think about the internet, often it's in the sense that through the internet, we will have more freedom. Through the internet, we can escape the impositions of the physical world of both corporations and governments. And that freedom might be achieved if we can just get the technology right. But as we know, the material world is quite stubborn and stubbornly resists all of these possibilities. In India, the idea of a shutdown culture is well documented. India leading the world in shutdowns and slowdowns of internet infrastructure. And so that comes this really important question that I think we all need to grapple with. On the one hand, we have the vision of the internet as being a technology that somehow intrinsically provides freedom, but yet a technology that is structured through large global corporations that we rightly should be suspicious of. Does Facebook have our interests at heart? Well, probably not. But on the other hand, a space that is also structured through material infrastructures and controls by governments. So how are we then arriving at these notions of freedom? And what I'd like to do in this talk then is to think together about what we mean by freedom by asking these two questions. Who controls the internet? And how is the internet controlled? Now, to get at those questions, I'll have to give you a little more background and just set a little more context. And one of the key issues here is how we get from this physical infrastructure of the internet, whether it's submarine telecommunications and the cables that you see on the left that provide high capacity international connectivity, or things like cell phone towers that most of us access the internet through, or our wireless routers at home. That's my wireless router connected to a phone line at home. How do we get from this very physical material infrastructure that we can touch, that we can see around us, to this virtual cloud that is somehow really hard to locate and hard to find? And also then, how do we get from a world in which we think about the virtual as being constructed in a struggle between corporations and governments over who should be allowed to speak, right? As we've seen recently in India. But also the physical world as being a struggle over who gets to regulate and control, whether through the Telecommunications Regulatory Authority of India, TRAI, that I'm sure many of you know of, or internationally with the International Telecommunications Union, which is a UN body that regulates, as the name suggests, international telecommunications. So what makes the internet different? Why is it that when we can see these kinds of corporate and state controls at these two levels, why is it that we imagine the internet to somehow be a different space that offers a different set of political possibilities for freedom? And the answer, I think, at least from my work, what I think we need to pay attention to is what's often called the logical layer of the internet. It's the set of technologies that interface between the physical infrastructure and this appearance of virtual space and help produce that appearance. And I'm going to walk you through in the next couple of slides very briefly what goes on in the logical layer, how it's structured, and through that, how we can think about the politics of these technologies of the logical layer. So let's say you're me, perhaps with more hair on my head, trying to get to the NCBS website in Bangalore. Now, this process of me getting from London to Bangalore could be understood in a couple of different ways. The first way I'd like to think about it is as a stack, right? So every computer, every little computer has the stack inside it. Now, there's a lot of detail here. I don't want you to worry about taking on too much of the detail, but suffice it to say that we have these layers in the network where the application layer sitting on the top is what we interface with, is what most of us use all the time, where we have, technologies like HTTP, through which we access the web, SMTP, through which we access email, and so on, right at the top. And right at the bottom is the actual physical infrastructure, radio waves, optical fiber links, copper phone lines. And in between, we have all of these other technologies that layer up, where we have things like Wi-Fi that runs over radio waves at home for most of us, and SONET for optical links, and PPP for telephone lines, copper telephone lines. Above that, we have a network layer where we have the internet protocol. That's where the internet first starts to appear, and then a transport layer, and then the application layer. But like I said, don't worry too much about the details. What we need to know for the purposes of our discussion is that the thing that we call the internet are these upper three pieces. The pieces down below could exist without the internet, and indeed do exist without the internet. The internet is something that gets layered on top of them. And very crucially, for the purposes of this discussion, and also for us to keep in mind, even while there are many different options for the technologies at each of these layers, right, whether we have physical infrastructure of radio or optical or copper, or many different kinds of applications, when you look at the network layer, there is only one technology. That's the internet protocol, or IP. And it's a key technology because it becomes a choke point, a critical point of control, because it's translating between many different kinds of physical infrastructures beneath and many different kinds of applications above. So it acts as that key translation language going up and down. And as such, then becomes a key point of control, and something that we need to pay really close attention to. Let me give you another way of thinking about the same problem of how I might get from London to Bangalore, thinking more now at the level of the internet protocol leading up to the application layer, this logical layer, as I called it. Now, if I open up my web browser and type in this address to try and get to the NCBS website, the first thing my browser does is say, well, I only have a name from you. What I really need to get to this website is the internet protocol address, the IP address that uniquely identifies the web server, the machine that is hosting the website. To find that, we use a technology called the domain name system. And my computer then asks one of the root servers of the domain name system, where is ncb.res.in? We get an answer back from the root server, which only tells me where .in is, because the root servers know where all of those top-level domains are, things like .com, .edu, now .gov, but also all of the country code top-level domains like .in. So then I go and ask .in, where is ncb.res.in? And the .in registry says, well, I don't know, go and talk to the .res.in domain name server. So it's kind of a hierarchy, it goes down. And eventually I get an answer back from .res.in that says, well, here's the internet protocol address. This is the machine that you want to get to. So now I know the machine that I want to get to. How do I get there? You can run tools to try and find the path that your data actually takes across the internet. I use a tool called traceroute that is available on most computers. And I trace the route that the data takes from my computer to the NCBS web server through a system that's called the interdomain routing system that literally routes the traffic between different domains on the internet. So what path does the traffic take in getting from London to Bangalore? The first step is my computer talks to my wireless router and says, I want to contact 158.144.176.51, which happens to be the address of NCBS. That in turn sends the data on to my internet service provider in London, Zen Internet, which connects to another service provider called AboveNet that can carry traffic across the UK and carries it into Europe. AboveNet connects to another network called Zayo, that has international connectivity and can carry the traffic now over towards India. And eventually Zayo connects to Airtel, and Airtel carries the traffic to the NCBS web server. And so we see a few really interesting things going on from this account. And again, I know there's a lot of complexity here. I can unpack it more, but I want to give you enough of a flavor of what's going on underneath the hood. Right? That there are many points of control that we can see, whether in terms of the domain name servers and who gets to see what, who controls what names can be seen, or in terms of the way the traffic is routed around the network and who is able to, again, see the traffic being routed around the network and who can control that traffic as it's being passed around the network. But what we see within this analytically, I think something that's useful to pull out from this, on the one hand, we see a problem of standards, right? That we need to have common technical standards to make the internet work. There needs to be someone who's setting the DNS, the domain name system, technical standard. There needs to be someone who's setting the internet protocol address standard and standards for a variety of other technologies that allow this particular system to work, right? And literally thousands and thousands of different technologies that are working together. So that's the first of our control problems. Right? Who controls the standards? What does it mean for them to control those standards? The second control problem we see here is one of resources. Who controls the allocation of names in the system? Who decides that NCBS is entitled to the ncbs.res.in name? Who sets policy for the allocation of those names? Who controls the allocation of internet protocol addresses in the system? Who gave NCBS that internet protocol address, right? Who ensures that there's uniqueness of these identifiers globally? Because every internet protocol address must be unique. It can't be allocated across two computers in general. Similarly, every domain name must be unique. Otherwise, you don't quite know where you're going. The system won't work if we don't have uniqueness. And finally, how is power organized within topology, which is when you look at the interconnection of networks and the interconnection of the different systems that make the internet, who has more or less power at different locations, right, within that system. And so whether it's thinking about the relationships between domain name servers, the root servers to the country code .in server to the .res.in server, or thinking about the topology of connections between different internet service providers. And so in the remainder of this talk, what I'm going to go do is talk through each of those areas in turn and give you brief histories of the global internet and how it came to be, but also put that in context of the Indian internet and how that's evolved in the Indian context. So the first part of the story is about standards, and standards for the internet are set by an organization called the Internet Engineering Task Force. It's an interesting organization. It has its roots in the very origins of the internet. So the internet began as something called the ARPANET. It was funded by the Advanced Research Projects Agency of the US Department of Defense way back in the 1967 onwards. And here's a sketch of the very earliest network diagram of what became the ARPANET, which just these 4 nodes. The ARPANET, of course, grew to many kind of hundreds of institutions by 1980, and eventually was taken over by the National Science Foundation in the US, right, to build the NSF-net that was then privatized to form the thing that we today call the internet. And so the roots of the internet then are very much in government funding, right? Initially through the US Department of Defense and the Advanced Research Projects Agency, and later through the National Science Foundation. But the roots of the internet are also in a research community that was trying to make these systems work. They were experimenting, they weren't sure they would work. They were constantly developing things to give us what we have today. And that research community is what came together in the Internet Engineering Task Force. And it came together with a very particular ethos that is today expressed in this slogan. We reject kings, presidents, and voting. We believe in rough consensus and running code. So the IETF is a very unusual standards organization. Most standards organizations have formal membership, have formal voting to see if the membership agrees on particular standards. At the IETF, there is no membership, there are only participants. There is no voting. Now, standards are now approved based on a rough consensus within the people involved in the formation of those standards. And it works in a variety of ways across the IETF. Now we can think of this as kind of an almost idealized standard setting mechanism, something that we could look to for the future. But it's important to remember also when the moment you look at who the contributors are to the IETF, the vast majority of technical contributions to the IETF still come from the United States. Right? There is like a growing number of people from around the world contributing, but the US still by and large to this day dominates contributions to the IETF. And there is a struggle over who should be setting standards for the internet, where the International Telecommunications Union, the ITU, has tried to step in several times over the years. And right now, again, there are proposals for what's called a new internet protocol led by Huawei at the ITU. But the IETF remains the principal standard setting body for the internet. Now, the next question that I'd like to talk about is that of topology. Right? I gave you a little sketch of how traffic moves from London to Bangalore for me to get to NCBS. But when we look at the global internet, this is what it is. It's more than 70,000 individual networks operated by different organizations, which are announcing currently more than 800,000 blocks of internet protocol addresses. And this little visualization shows that where every dot is an individual network, and you can see how they're connected. But it gives you an idea of the scale of what we're actually dealing with here, and the scale of what we're trying to govern and the complexity at play. Of course, once we look at this within particular contexts, with particular regions, we get more granular perspectives, and we can start to see how it's not always as complex as the global picture. So in India, for instance, if you look at, well, a proxy for topology, right, would be the relative market shares of different internet service providers. And you can see, I'm sure this is something that will not surprise anyone on this call, that Reliance Jio, Bharti Airtel, Vodafone, BSNL dominate the Indian market. Right? And so there's a relatively small number of access providers in the Indian market that are also control the backbone infrastructure that carries traffic nationally across India. And these are, of course, regulated by the Telecommunications Regulatory Authority of India, TRAI. And so we have these two senses of topology. On the one hand, global topology that is really structured through a very complex interaction of market forces, national and international regulations. And then the topology within India, which we can understand much more within this regulatory framework of TRAI and the history of these particular companies and how they've chosen to invest in their networks. Now, how did we get here, and how did we arrive at this topology? Now, one of the pieces of that answer lies in something called NIXI, or the National Internet Exchange of India. You'll find it around the world, there are these physical locations called Internet Exchange Points, right, or IXPs. And Internet Exchange Points are locations at which different networks can bring their physical infrastructure, their actual cables, and plug them into each other, which is how we get this 70,000 odd network system interconnecting. That there are these physical locations where they can actually exchange traffic Not all of those are at internet exchange points, but many of them are. Now, most internet exchange points around the world are non-profit entities. Right? In fact, if you look even within South Asia, in Bangladesh and in Nepal, the internet exchange points are non-profits. But the National Internet Exchange of India is actually operated under the Ministry of Electronics and Information Technology, which gives us, again, an idea of internet exchange points as being these key points of control that allow the interconnection of networks to form the internet. And so one of the questions we have to ask in terms of thinking about this idea of freedom is, how are these exchange points controlled? Like, why is it that in the Indian context, we have something that is a public-private partnership, operated under the Ministry of Electronics and Information Technology, rather than a nonprofit, as we see in Bangladesh and Nepal, and indeed in many other parts of the world? Now, the answer comes from the history of telecommunications in India. Now, in the 1980s, we had two different departments, the Department of Electronics and the Department of Telecommunications. And there were a number of Indian scientists who were aware of the work going on in the US in the 1970s, where they were building the ARPANET, the predecessor to the internet, who came back to India and started advocating for similar kinds of technologies. And that was what gave rise to EARNET, that we still have with us today. Now, EARNET was limited in many ways by the Department of Telecommunications at the time, where the Department of Telecommunications played a number of different roles. It was the regulator for telecommunications, right, nationally. It was also the operator for telecommunications nationally, right? And so EARNET, in order to function, had to actually, in a way, almost compete as operator with the Department of Telecommunications, which, of course, with DOTB also being a regulator, that didn't quite go so smoothly. Now, in the 1980s, while DOT was the operator for most of India, we had MTNL set up separately, covering just Mumbai and Delhi, and VSNL to provide international connectivity outside the country. And so when EARNET initially wanted to connect to the global internet internationally in, I think, 1986, it got a connection through VSNL to connect to the global internet. Now, over time, these functions were spun out of the Department of Telecommunications, where TRAI was set up in 1997 as an independent regulator. Operations of the actual physical infrastructure was spun out to BSNL in 2000. And VSNL was privatized and sold to Tata Communications in 2003. And Tata used that, of course, to build a huge global international network. Now they have one of the largest international networks in the world. And this was the context in which NIXI was created in 2003 as the operator for internet exchange points within India, providing key points of connectivity as private ISPs were created after in 1998, when TRAI came up with regulations that allowed private ISPs to be created, and they needed spaces to interconnect. And that was the function that NIXI played. Now, this isn't the only thing that NIXI does. NIXI also has a role to play when we think about resources, right? Now, globally, we have a couple of different kinds of resources that I'd like to talk about. And the first are domain names. And domain names are managed by ICANN, or the Internet Corporation for Assigned Names and Numbers, that has global authority over domain names. It controls what top-level domains like .com or .edu are allowed to exist. And it also kind of operates the country code top-level domain names like .in under contract. Now, ICANN was originally set up under contract with the US Department of Commerce and the National Telecommunications and Information Administration of the US Department of Commerce. Now, over time, they have removed their oversight, and ICANN is nominally independent, but it remains this key international organization overseeing the international regime, the international allocation of domain names. And so it's important just to think about how ICANN is governed, right? Again, points of control. How is the allocation of domain names controlled? How is the domain name system controlled? Now, I know that this is a rather complex visual, but what I'd like to draw your attention to is this, that the board of directors has a governmental advisory committee in ICANN. So the governments of the world have no vote at ICANN. The votes at ICANN go to technical personnel. They go to the companies running the domain name registries and the registrars for those domain names. Countries nominally have a vote through their country code registry, so they can represent the interests of the country code registry. But in terms of overall policy for the allocation of domain names, they don't have a direct vote. It's only advisory, and this has unsurprisingly caused significant tension in the world of internet governance. Now, the other kind of resource that we need to think about are internet protocol addresses that I talked about earlier that also need to be unique, like domain names. And these are allocated through the 5 regional internet registries, as they're called, where APNIC, or the Asia Pacific Network Information Center, covering our region of the world. Now, these are nominally operated under the regime of ICANN, but really they function by and large independently, where ICANN looks mostly after domain names, while the regional internet registries manage the allocation of internet protocol addresses and other kinds of number resources required to make the internet function. So how does India fit into this? Now, NICSI has an entity called the Indian Registry for Internet Names and Numbers, or IRAN, that also operates the .in registry. So all of these entities are really operating under the Ministry of Electronics and Information Technology in India, under the purview of NICSI. NICSI now operates the .in registry under an agreement with ICANN as the national operator of record. And so anything we put into the .in registry is subject to policies set by NICSI and by the Ministry of Electronics and Information Technology. NICSI also gets internet protocol addresses and other numbering resources for allocation within India from the Asia Pacific Network Information Center, operates under contract with APNIC. So now we have this interesting system where we have a Californian nonprofit entity, ICANN, that oversees the allocation of domain names, which doesn't really allow, to which nation states don't have an explicit vote. But yet nation states must contract with ICANN, follow ICANN policy, right, to some degree in the management of their country code top-level domain name registries like .in. And we have the regional internet registries, which function on their membership that's basically in these registries like the Asia Pacific Network Information Center, APNIC, policies set by the membership. And the membership is anyone who has got resources. So any network that has received internet protocol address resources, that are the resources from APNIC, can vote on how policy is formed. But NICSI must again operate under contract with APNIC. And we have this very weird inversion of the way that we normally think that governance and politics should work, where normally we assume that at the international governance level, countries might reign supreme. Now we see a much more complex account where there's a combination of technical communities, corporate interests, and nation states all contending for control of the system. And that's where I will close my talk. I mean, just to wrap things up, when we think about how we get from physical to virtual, this apparent divergence, and when we think about the logical layer as a thing that actually produces the physical, the virtual over the physical, we need to think about it more than just technology. That it's anytime we say that the internet is technology that gives us freedom, what we need to pay attention to are the points of control within that technology. and how we hold those points of control to account. Whether it's in the standard setting process, whether it's in the allocation of critical resources like domain names or critical resources like internet protocol addresses, or in how all of these different functions, standards, resources, and the actual topology of interconnection play out within our own national context. And so to think about freedom then, we need to think about the places in which control is actually quite necessary. In order for a system to function, we must have a single point of control for standards. We must have single points of control for the allocation of unique resources like names and numbers. We must have appropriate regulation or perhaps shared infrastructure of internet exchange points in things like NICSI. But the question we have to ask is, if we want freedom from the system, we shouldn't be asking what technology should we build. That's not only what we should be asking. We should equally be asking, how do we hold the institutions that manage the technology to account? And I will close there and turn to Apar. Thank you all.
Thanks so much. It was fantastic. Apar, over to you. Thank you. Sorry.
Thank you so much, Venkat. Thank you, Ashwin. I think that your presentation quite clearly uh, brings to surface stakeholders which are not conventionally viewed as exercising control over how we interact with respect to digital technologies, and secondly, whether those frameworks and that larger environment, which is then designed by these stakeholders, is democratic. Because I think what links to that question of freedom and the extent of freedom is also inherent or an implicit recognition that the bodies which are setting the standards, which are designing the architecture, need a level of democratic legitimacy in making the choices and the decisions that they are making with respect to allocation of resources, the priorities, and names and numbers ultimately, because they are limited. I'm going to talk about a much more uh, obvious element of freedom, which is the existence of democratic oversight through institutions of governance nationally in India, which are the courts, which are our parliament. And I would state that they are more democratic in the sense that ordinary people do interact with these processes. They do know about them. But are our courts and our institutions also fairly aware about this larger ecosystem and topology which exists around digital technologies? For this, I'll be taking certain contemporary examples relating from how certain legislative, regulatory, and adjudicatory outcomes have come about, and how it is completely ignored the layered infrastructure of the internet, the multiple stakeholders which are present there, and why, and possibly examine, which is towards a later conversation after I end with the initial remarks, is that how best can we integrate this understanding uh, within the larger assessment, which comes through a form of legality, through regulation, or through adjudication in terms of court decisions. So, firstly, the primary legislative framework for any kind of electronic commerce in India was determined to be the Information Technology Act. And the impetus for it was the unification of laws all over the world to give recognition to electronic contracts, because the internet, uh, at least towards a system of recognition, was first recognized as requiring a level of national legislation which would give recognition to online commerce, where the shopping cart and the ability to transact business online needed a degree of legal recognition for enforceability of agreements and contracts. And this was taken forward from a model draft drafted by a body of the UN, which is called UNCITRAL, towards a legislation in India called the Information Technology Act, first as an ordinance and then as a legislation in the year 2000. It was subsequently amended. Its focus also changed, and we know it more because of the controversial aspects of how control is now exercised over censorship. And it's used primarily as a model of censorship rather than it giving recognition to electronic contracts. So I'll chart some bits of that journey right now. Prior to stepping towards it, also just in terms of the response to what John Perry Barlow stated, we see very tangibly uh, three trends which were asserted by Jack Goldsmith and Tim Wu in a book called Who Controls the Internet and Illusions of a Borderless World, where they stated that the state will continue to maintain a level of primacy in determining how the internet is structured. Of course, it again reinforces the absence of consideration of the layered architecture and the complexity in which the architecture then operates through standard setting bodies as well as the technical intermediaries which first operate at the physical layer and then go towards the application layers. So I would say that my first learning quite often has been that when lawyers and legal scholars look at the internet, there's an inherent bias to look at the pre existing democratic frameworks of regulation and completely ignoring the larger and much more complex topology in which the internet as a digital technology operates. And we see this as a recurring theme, not only in the work of such scholars who do account for it to some degree, but even in the work of what we call is a very vibrant space today, which is called tech policy. However, some of these trends are fracturing as there are conversations emerging around who controls the new infrastructure layer. Does a large cloud-based provider such as Amazon Web Services itself qualify as operating essential internet infrastructure, which if it uses to deplatform a business, leaves that business or that person without an alternative? So there are core arguments of freedom which come with a level of a democratic oversight, which is some or participation in decision making, which is sometimes lacking. And these are trends which we see reoccurring whenever we talk about other much more contextual and contemporary debates we're having today, for instance, about content moderation on Facebook, where there are only imperfect prescriptions being made with respect to transparency, with respect to accountability, and principles which are being then prescribed them. And I think this also emerges from certain bits of adjudication. Quite quickly going through them, one of the seminal cases before the Supreme Court was with respect to the arrest of two young persons who posted messages on Facebook and were then arrested under what is now unconstitutional provision called Section 66A of the Information Technology Act. This provision was vaguely phrased, was rushed through the Indian Parliament, and essentially criminalized any form of speech which could be open to legal prosecution. And I say any form of speech because the provision itself was vague. However, this litigation also concerned two other aspects of the Information Technology Act. One was with respect to the safe harbor exemptions present for intermediaries, which may be internet service providers or informational service providers, such as social media companies, in which they are not held liable for the content which is published or transmitted over their networks by end users. Now, this may this may inherently recognize a layered architecture of the internet, but what has been an initial understanding that these are infrastructure providers who should not be burdened with liability is now also receiving a considerable amount of reflection, given that the power of these providers, both at the level of internet service providers in certain markets and geographies, as well as social media companies, so showing a level of concentration where there are no viable alternatives to their market power and existence. And what is the result of that is quite often is that it results in undermining individual freedom of choices. Now, that freedom, if is constrained by private operators, what are the solutions towards it are also very, very disputed. So as much as they're not held liable, there are additional obligations which may be imposed on them to maintain their exception from liability for the kind of content which is transmitted over the network or is hosted or is published on that network. So Twitter is not liable for a Twitter user what they post as a tweet, just as a telephone company should not be liable for a person who phones in a bomb threat to the annoyance or to the to the disruption of any kind of civic activity. So this understanding right now is in stress because these conventional doctrines are not holding true any longer. And here I think the layered understanding of the internet and digital technologies, which can be viewed as a controls track and a much more holistic understanding, is necessary and should input into what is again a very vibrant field of policy, which is called tech policy today. This third element of the challenge in the Shreya Singhal case was with respect to website blocking. And in that instance, the court essentially upheld the provision for website blocking, stating that it does not result in an immediate criminal sanction. And if a person wants to challenge a website block, they can always approach a court. However, the regulation comes with a high element of secrecy attached to it. And even when websites are blocked, which was the conventional exercise of this power, natural justice, which we call in terms of a person receiving a notice or a show cause opportunity before action adverse to their fundamental rights is taken, for instance, for a book ban or for disability which is placed on their fundamental rights, does not exist with respect to website blocking. It's again sent to the intermediary. So it's the internet service provider or the large social media entity which is given a notice by Mighty, which what Ashwin was talking about, and heads the committee. So the Mighty, which is the government committee, sends a notice to the intermediary rather than the end user. And the intermediary does not have the full incentive of disputing that notice or is not well equipped at that same point to also to marshal evidence in defense of the content in question. So quite often it results in a block of that website without a compliance with natural justice by itself. So here again, there's a large question which emerges in terms of the design of the regulation and what are the rights for freedom which flow towards the end users itself. Because my understanding quite uh, 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 emerges from looking at the individual and the user as the true beneficiary of this freedom rather than the network by itself. Secondly, the court, while it strikes down Section 66A, states that with respect to intermediaries, any kind of takedowns which take place need to come from a court order or any kind of executive authority sending a legal order. Uh, it also states that the website blocking regulation is valid, and if you are aggrieved by it, you can approach court. And due to this outcome, the website regulations which are there for blocking remain the way they are. And the process right now also comes with a high amount of secrecy where the orders for directions towards blocking websites or individual web pages remain secret, which is why the recent order which has been issued against Twitter remains secret till date. Now, shortly after the Shreya Singhal judgment in 2015, which was a litigation that commenced in 2013, we noticed another very interesting point of regulatory debate in India, which is around network neutrality. And I remember this very clearly. In 2015, right after the Shreya Singhal judgment, there's a consultation which is commenced by the Telecom Regulatory Authority of India on two distinct issues. The first is, should internet service providers have the ability of charging end users on the basis of what websites do they visit? And should internet service providers also have the ability of demanding money from large Silicon Valley companies because disproportionately their networks are servicing user requests for querying information and data from these large Silicon Valley companies, thereby burdening their networks by itself. And for network expansion, these internet service providers and telecom companies need to have the ability of demanding a certain sum of money or entering agreements with, let's say, a Facebook or a Google. Now, this conflicted with a principle which is called network neutrality, which is essentially that if you double charge a user, you restrict or you even place a charge on a website owners or even a Silicon Valley company which has the ability to pay a large amount of money. It shuts out the other people because it creates certain financial incentives in which the players which are dominant increase in size, and it restricts discovery as well as the ability for other services to compete with them, and also shuts out individual blogs and websites. The second part of the consultation was around licensing of what were called over-the-top applications. This led to the Save the Internet movement. The Save the Internet movement essentially again argued for a greater amount of user control in personal choices in approaching any kind of access to web services. But again, it did not approach it very clearly from an inherent understanding of network infrastructure and how is the stack designed. This is not to say that people who do understand it did not contribute and collaborate on it. There were two specific academics who contributed thought on this. The first is Barbara Van Shevik, who's written a book on internet architecture and control. And the second is Professor Vishal Misra, who designed much more of the and ran through simulations much more uh, on the pricing model and the incentives that it would create through applications of game theory also, which he subsequently published much more recently. I invite you to look at it. The outcome of the Save the Internet campaign was a ban in price discrimination by internet service providers. And secondly, we are stepping towards also a regulatory regime where beyond price, even other forms of technical discrimination, which can determine different types of data to be uh, to be preferenced and discriminated is also subject to regulatory overview, where ordinarily an internet service provider should not tinker with how the packets are being routed beyond the standard setting and the network protocols, which already determines which packets get a higher priority. For instance, the Zoom call, right? It can't work if there's a certain priority not present within that framework. And I'm ignorant about this. So I would hope Ashwin corrects me if such a priority does exist within the protocols which exist right now. But these were the arguments being made at that point in time. So the regulation here does recognize that there'll be certain standard setting. However, again, the enforcement is left primarily to the internet service providers as a self-governance framework, which is subject to oversight, publication, which brings and transparency, which brings a higher degree of accountability. And without technical reasons, for commercial reasons also, they cannot discriminate by itself. So here again, the centrality of technical standards and what can be the needs of that network by itself take higher amounts of preference. One exception carved out in this is legal orders and requests. Again, it goes back to the blocking power. And here, just to complement what Ashwin was saying earlier, there is actually a standard called which which has been prescribed. I think it's 451, which is a HTTP status code for when websites are blocked, but it's not implemented in India. Where any kind of legal, I've pasted it in the chat box. So essentially, it states that. This status code indicates that the server is denying access to the resource as a consequence of a legal demand. So just like an error code 404 shows, error code 451 will show. And it's inspired by Fahrenheit 451, Ray Bradbury's dystopian novel, which opens with the declaration, "It was a pleasure to burn." And burn what? Burn books. So it's somewhat it's somewhat critical of this practice by itself. Maybe that's why it's not been implemented. But what it does is very important, because today what we have, whenever a website is blocked, a person is left wondering and in a state of confusion, why is this website not loading? Is there a problem with my computer, my browser, my router, my internet service provider, my phone, or it's a legal request? And even when it does come, certain times that there's been a legal request to block, the reasons are not there. So is it a copyright demand? Was it a defamation case? Does it relate to a much more social concern? So the degree of transparency is lacking. So this is also a very interesting way how standards can actually also pose opportunities when adopted within legal frameworks of how democratic processes and at least freedom can be enlarged. Now, finally coming to internet shutdowns, which are much more recent happenings around internet freedom. Internet shutdowns by legal scholars internationally have always been reasoned to be disproportionate restrictions on free speech, because it's presumed that most people do not talk about making bombs on the internet. They're in fact, if you look at how data is flowing, they're doing fairly mundane tasks. For instance, having Zoom calls, gaming, or doing other sorts of daily activities. And it's activities is integrated very closely to human function today. So if you turn off the internet in a geography, you're turning off a whole set of functions rather than just individually prohibiting behavior which may be illegal, which is the underlying justification of the order why you require that internet shutdown to take place. And the internet shutdown orders, at least prior to January 2020, when the Anuradha Bhasin judgment was given in the context of the communications blackout in Jammu and Kashmir, um, prior to that was being done under two regulations. The first is with respect to Section 144 of the Code of Criminal Procedure, um, which is essentially a power to prevent illegal assemblies, which also has a subsidiary power of directing through a notification any kind of conduct which is required for a person to do, or abstaining from that conduct with respect to any kind of private property. So it's been also used to confiscate Gandhi caps, but it's also a power which has been used to direct internet service providers to turn off access to the internet, which is sent to district zones where all these where the physical architecture itself of providing 4G internet access is situated. And internet shutdowns have been effected more regularly for mobile-based internet services than landline-based internet services, which also speaks to the demographic and certain other political considerations. The TRAI reports consistently show that most people in India access internet over mobile devices. Secondly, there is also throttling which happens, as we've seen in Jammu and Kashmir. So sometimes these internet shutdown orders say only permit 2G rather than 4G. So people can't access a whole suite of services. They can't even upload videos. And the political context around that is quite often is that when protests are taking place, people use technologies to organize, which is also the right of assembly. So freedom is not only the freedom to speech, it is the freedom to receive information, it is the freedom of digital assembly, which is quite often put at stake with how the physical architecture of accessing the internet itself is placed within a specific geography. And that dependence comes through again. Okay. The second regulation, which is used after the Anuradha Bhasin judgment, at least if the judgment is implemented, which is not happening at present, is under the Indian Telegraph Act. And the Indian Telegraph Act has no conception of a layered architecture of the internet, which is the primary enactment for, even though services under it and agreements under it may recognize it, the act by itself is essentially towards vesting the power of operation of telegraphs within the government. And it also has a very interesting historical background. I think Vikram Raghavan's book on communications law in India does chart some bit of it fairly accessibly, in which it shows that there are links to the first freedom struggle, which is also called the Sepoy Mutiny against the colonial state. And one of the first things which is done is that there are a whole range of enactments which come through, but and make that control much more legally centered within the government by itself as an exclusive monopoly. And the telegraph has been this monopoly. But the Supreme Court in landmark judgment in 1996, which is called the Cricket Association in Bengal, says that it is control but not monopoly in favor of the government, because the government essentially exercises the role of a trustee or a guardian, and it's holding the spectrum as a trust in public welfare. Now, there's no layered understanding within the Telegraph Act. The services are auctioned to private telecom operators, and then the earlier auctions which take place according to specific geographies which constitute circle-based zones are also unified into zones, and also the services are all then unified, and a unified license comes into space from what were earlier distinct services which were allocated as per licenses, which included email services as well. So there was a distinct license for email services, and technically Hotmail was illegal at that point, but that was not agitated. But so what you also look at is there's a large uh, desire by government to keep controlling the different layers from the physical to the application layer and situating it within a geographical basis to exercise control. Now imagine what does that mean tangibly in our current environment of tech policy debates. and why does the government make this repeated demand about data localization? It's about not only physically situating data within India as an economic resource, but also about a culture and an institutional learning which has been predominant within it to exercise political control based on notions of sovereignty, which also have very large questions and implications for freedom. Uh, Finally, I would just like to end this by inviting greater amount of conversation around how can a layered understanding of these technologies, which sometimes look like magic, which we do not consider from the very beginning, be inherently placed within policy design. And uh, I would, given the audience here, also like to pose a much larger question. Is it even necessary?
Thanks so much, Apar. Um, Ashwin and Apar, thank you so much for this context and then the way you sort of really brought a lot of these ideas together. I'm wondering, so I'm curious. I have one question that I wanted to share with both of you, and maybe you can sort of address it because Ashwin, you alluded to this right at the beginning when you talked about different points of control. And one point of control I'm maybe just naively curious about that we haven't really spoken about is around access. And I think Apar, brings this in his conversation around how do we think about access. And so are there ways in which we can think about how to contextualize what's going on in India versus other parts of the world about what are the regulations around access to the internet, at a very, very basic level? I mean, are there ways in which other countries see it differently compared to how it is in India? Is it simply much easier to quote unquote turn off access in this space compared to other spaces in the world?
Well, I don't know that it's any easier or harder. Um, but if you look at the access infrastructure in any given country, there are typically a small number of providers that provide access, and it's typically a relatively small number of technologies. So we talk about wired versus wireless, like typically is it 4G internet, right? Now 5G as is emerging now, 3G or perhaps even 2G if you're looking at Kashmir, for example. Or is it wired? And there are different providers on each of those paths. But when you look at those physical technologies, they always get aggregated somewhere for carrying the traffic to the broader internet. Some of those central points of aggregation in India are at NIXI, of course, National Internet Exchange of India. But even prior to NIXI, I think Apar was talking about the kind of zonal blocking that happens within particular regions. There's always aggregation of connectivity from, let's say, different wireless towers. If we're talking about 4G, there's always aggregation of the different phone lines or fiber optic lines that are coming together somewhere. So the moment you look at that physical topology of the networks, even administered within particular providers, and those providers always have points of control, right? And regardless of government intent. Right? The question though, and I think this is where Apar can probably say more than I can, is what kinds of legal regimes we have that allow orders to be issued to those providers to actually enact those blocks or not, and what provision those providers have to actually respond to those kinds of requests. Apar, I'll let you.
In terms of legal regulation, Venkat, it's fairly tough to turn off the internet. Globally, it's only been seen in um, some countries in Latin America and Africa, which suffer from social strife and a weak rule of law process. uh, because it gives exceptional power to arguments for turning off the internet as an infrastructure itself, because it also contradicts uh, uh, the narratives of technology being a great liberator and empowerer for the empowerment for the masses by the same political leadership. So that's why there's always a tension when you turn off the internet. It cannot be done as easily as it's done in India. And there have been significant court victories even in Africa. I think there's a judgment in Zimbabwe around this. There has also been similar judgments, um, uh, some judgments on localized internet shutdowns. So I'm just in the domain of internet shutdowns. I think domain seizures and website blocking becomes a bit more complex because these are seen as being proportional restrictions. So the doctrine of proportionality plays a very big role here. And we have not, even in India, seen conventionally website-based blocking based on domain seizure through NIXI, but I have dealt with a case recently where Let India Breathe, which is an environmental collective, which was organizing a campaign to encourage people to reach out to a government ministry on the environmental impact assessment law to participate in a public consultation was blocked because the volume of the email was so high. Nixie reasoned that this was a website engaging in spam. So we had to have a conversation with them. But historically, I've not seen any kind of political censorship emerge on domains by itself through Nixie. There was one other instance of a private complaint against Wikipedia when I was serving as a, which was carried in the press also, where there were complaints about obscene contents being hosted. And Nixie did try to exercise control, but it quickly realized it's outside its jurisdictional remit, even legally, and it was open to reconsidering its actions around it. Website blocking takes place under a very distinct process in India, where orders are sent by a government committee which has members of the Ministry of Electronics and IT and other bureaucracies. With respect to content-based takedowns, legal orders are sent by courts and any government department. So it can be it's quite broad. So theoretically, even your municipality can send a order under a law to internet service provider or to large social media company to take down something or to remove an information resource. But thankfully, that's not happened to that extent. It's the social media companies which get these kind of requests.
Thanks. And I think you alluded to this during your talk to say that, in a sense, they're intermediaries who don't really have much stake. So when they get an order, they just sort of, in the end, the default option is just to go ahead and comply with it because they're not they're not the end user, so to speak.
Yeah, which is also why when Twitter in the recent instance has been asserting that the orders which have come to us for suspending user accounts are disproportionate and they are outside the reasonableness doctrine, which permits restrictions on free expression. People are saying, who are you to make these arguments? It should be end users. But the problem is the end users, due to the design of the regulation, do not have an opportunity of being a participant in the process by itself. So they do have a lesser incentive. Secondly, this incentive this lack of incentive has also been practically demonstrated through a research study of dummy takedown notices, which were sent uh, through a researcher in India called Rishabh Dhara, who did a research paper at the Center for Internet and Society. And the notices were intentionally vagued very vaguely, uh, and uh, 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 and the findings were that the takedowns were affected. So, which is why the court in Shreya Singhal said you need to go through a filter. private complaints and notices are not enough. You need to go to a police station or a court. But also, uh, uh, going to a police station or a court is sometimes not an adequate standard just in terms of maintaining freedom. But also, we need to remember everything on the internet isn't just kosher or democratic.
Thanks, Apar. I have a few more, but I think there's a person named Syed who has a question that I'm just going to try and see. I've allowed Syed to talk. Syed, if you're able to go ahead and voice your question, could you do that?
Hello, can you guys hear me?
Yeah, please go ahead. Yeah.
Hey, thanks for letting me ask this question. So I understand that when the layered understanding of the internet was explained by Ashwin, there is a physical layer of infrastructure at the bottom, and then there's the internet protocol, and then the application layer. So I'd like your explanation of where do decentralized technologies such as the network of Ethereum come, on what layer do they come? And how would you understand Ethereum and decentralized finance in context of internet freedom in India? As in the financial ramifications themselves and the applications that can be built on top of blockchain. Thank you.
Thanks for that question, Syed. I mean, I think maybe I'll start with a response about layers and blockchain in general. Perhaps Apar can again turn to the legal framework within the Indian context for these kinds of contracts. But Ethereum is an interesting system. Blockchain is interesting in general, as are the broad swathe of decentralized technologies. But if you look at where they live in the layered model, they really live at the application layer and above. Right? These are overlays on top of the physical infrastructure, the logical layer that lie beneath. Now, the degree to which they can offer freedom, I would kind of turn back to the kinds of questions that I was raising about governance in general. If we think in terms of this framework of standards, resources, and topology, who sets standards for Ethereum? Right? And do you trust them? How can you hold them to account for building a technology that will actually fulfill democratic requirements, that fulfill ideals of freedom that can be broadly construed and not just within a technical domain? And so we've seen cases with Ethereum, for example, where there have been, I forget this, but there was a major flaw within the network, and it was hard. There were entire sets of contracts that couldn't be executed until that flaw was actually remedied. Right? Now, it's one of the pitfalls of decentralized technologies as well, that you then end up taking accountability away from institutions that could perhaps institute remedies and assuming that the technology can provide that accountability for you. And what I'd like to suggest is that technology is the architecture through which we inhabit the world. Think of it like the houses that we build, right? And the houses that we build influence the way we live our lives just because how they're structured. But we go and actually make our lives within those houses. And so to kind of place the responsibility on the house for the quality of our life is to forget that we are also responsible for that. The builder is responsible for it. The regulatory environment that ensures that the house is safe is responsible for the quality of our lives. And so what I worry about with blockchain technologies in general is that we're trying to take away that accountability. We're trying to say the technology will stand in for any kind of accountability that we need. The technology will allow us to escape the tyranny that we perceive from the state or from large corporations. And if we can only achieve that ideal state of individual liberalism, we will have freedom. But to that, I will turn again and say, well, who builds the systems? Who manages the mining pools? How are they actually organized? And those become the really key questions that we need to address if we are to think about these systems as democratic or not. Apar?
I'm sorry, I have very little to add on this. I have not studied Ethereum as a technology. Its legal regulation is being debated as well as other kinds of, I think, blockchain-based currencies, which through a pending enactment which may come through in the second half of the budget session of Parliament, more focused towards Bitcoin. I know that these technologies or financial instruments follow different models, but I've not looked at it closely, and I'm not aware of the legal regulation to give any kind of educated comment on this. I'm so sorry about it.
Just in the interest of time, since we're also coming upon 5:30 soon, I do want to sort of maybe wrap up with one broad comment or question that, and this is going back to something that Ashwin, you brought up right at the beginning of your talk, which was the ARPA 4-node network. And I'm just thinking, that's something from 50 plus years ago. And I'm perhaps genuinely curious because everything that I heard Apar talk about, this conversation around law and thinking, I was wondering, I mean, was there much of a conversation around law or regulation or, the philosophies of what is going to come forth after that, 4-node network? Are there any, details that you might have or, resources that you can point to tell us how people were thinking at that time of what was going to eventually become an internet? And perhaps as a corollary to that, I'm just thinking this is only 50 odd years old. And as an archivist in my current avatar, I sort of think of this as a blip. And so, 50 years out or 100 years out, I'm just wondering, are there conversations out there about a different kind of interconnected network that sort of, goes back to first principles and asks these questions in a more fundamental, I mean, maybe this is connected to this decentralized question that Syed asked. So I'm just wondering we take this as the only alternative there is, but I'm just wondering if there are conversations around reimagining the fundamental regulatory structures of the internet. So just two separate questions for either of you who want to take a shot at it.
I have a very quick answer. In all the parliamentary debates I've read, standing committee reports, it's essentially the experts who are called, they are always termed as techno-legal, but they happen to be legal. Okay, so I don't think so. Technologists have been inherently within the design of the legal regulations, but we see something very different happen much more recently. We have technologists who are then coming and determining what are rights entitlements now. So I think so much more symbiotic conversation has been fairly absent. So I do think so. If you do not think about the internet, but you think about other kinds of digital technologies, especially in much more recent policy documents, or even related to our political economy. If you just go through the National Economic Survey, it has a very high level of input by technologists, but more as technologists who are thinking about governance systems as stacks now. So it's reached that level. I'll stop here.
There's an interesting and long history through which I teach a course on the history of network technologies, Venkat, so don't get me started. But there is a very long history to the ideals behind the internet. And I think we need to remember that when it was being developed in the 1960s in the United States, this was also the period of the counterculture in the United States. And there are kind of very well documented links in the way that those ideals flowed in both directions as these technologies were being developed, right? That was the backdrop to this. And there's a scholar named Sandra Brayman, who you may be interested in, who has analyzed some of the early standards documents that came out of the Internet Engineering Task Force in the 1970s, and is looking for things that we think of as regulatory problems now, like ideals of privacy, and how engineers were already talking about those issues, even if they were asides within the standards documents. So I'd recommend her work. I think is quite powerful for actually looking at some of those issues. In terms of thinking about your provocative question about possible decentralized futures, I think it's one of the things that worries me personally, that we had that John Perry Barlow imagination of what the internet could be, right? And it was go away governments. It's you governments who are going to ruin it for us, right? And similarly, there's a narrative today which is go away large corporations. It's you Facebook and Google and so on. It's your control of platforms that is ruining for us. But this assumes that there is an individualist liberal ideal network that we can build, where that decentralization anticipates a liberal individual, right, who is reasoning as an individual, living life as an individual. What it erases, and what I worry about in some of those conversations, is that we forget to have the conversation about freedom as a collective right and freedom as a collective good that we can only achieve together, rather than freedom as fragmented individuals that we do just in the way that we assemble ourselves. It's not to say that one is necessarily better than the other, but I worry that the conversation about collective freedom is often erased in those kinds of conversations about what the internet might be. There has been substantial work on potential future internets, both academically and in industry. Some of which is directed towards decentralization. Some of it is directed to other kinds of naming mechanisms, internet protocols, and so on. And there's a very wide swathe of work there that I can point you towards. But
Thank you. No, thanks so much. Really appreciate it. I was going to wrap up, but I see this really, well, another provocative question that's coming from YouTube. So this is from Marisha Thakur, who asks, quote, "Hi, thank you both for being so lucid. Can you talk a bit about how end-to-end encryption can be a double-edged sword and be subversive, please?" End quote. Her words, not mine. You're welcome to take a shot at it if you feel like it.
Sure, I can take a very quick shot. I mean, thank you for asking us to be subversive. No, I agree completely. It can be a double-edged sword. And there was a movement of people that you may be aware of, the crypto anarchists in the 1990s, who were battling the US government around strong encryption, where there was a period when encryption was classified as a weapons technology. And so there's a famous case, I'm sure Apar knows about this, of Phil Zimmerman, who invented a technology called Pretty Good Privacy that's still widely used today. And they actually took him to court saying that, oh, you exported the software. Other people are using this strong encryption around the world. But of course, by the time it went through the courts, it had spread far too widely for any judgment to have much effect. Now, the conversation about encryption, I think, again, is an interesting one. It goes to this issue of individual versus collective freedom, right? That we often think of this end-to-end encryption. Why do we need it? And that's one of the core questions for me when we think about what do we mean by freedom, rather than just an abstract concept. For what purpose are we trying to deploy freedom? Is it that we perceive a monstrous state or a monstrous corporation as eavesdropping on our conversations and taking advantage of the content which we're communicating, right? In which case, perhaps individual to individual encryption is a good. But on the other hand, as I'm sure you were thinking when you asked us to be subversive, there's equally a problem of distributing child porn, for example, where encryption can actually shield abusers, right? Or criminal activity in general. And so governments have asked, also proposed that, oh, we can have backdoors to the encryption. Trust us, we'll hold the keys separately. Don't worry, you'll all be fine. And again, I fear that I'm not being subversive enough for you, because I don't have a good answer one way or the other. I can point to the tensions, right, where there is sometimes a need to surveil, where law enforcement might actually have a rightful need sometimes to surveil when we're actually thinking about something that's criminal. But the question of defining what is criminal, right, especially in these turbulent political times around the world, becomes a really tricky one. For now, at this moment, in this political moment, I am personally glad that we have individual strong encryption available to us. The question, though, is what kind of future are we building when we deploy those technologies at scale?
The legal understanding of encryption has been that under the telecom licenses, the companies are not permitted to deploy what is called bulk encryption frameworks. So by itself, and also there's a regulation of the strength of the encryption. So for instance, it's a 256-bit RSA standard is not permitted. It's about 40-bit, I think. So some things like that. So it's fairly strange. I think encryption is not a double-edged sword. I think it's a shield. I think we are mistaking the edge cases to be the center, and then prescribing quite often what's happening. For instance, building backdoors in encryption, weakening it consistently, because encryption in today's environment is not only a system for evading political censorship, but it's also sometimes a way of ensuring that data capture does not take place, which builds a larger surveillance economy, which has fiscal and political motives attached to it. I've had conversations with two academics regarding this, just to inform my very apparent subversive political bias. One is Dr. Manoj Prabhakaran, who's furnished an affidavit before one of the courts in India, also describing how the report by another technologist, Professor Kamakoti, on encryption and building backdoors will not lead to the kind of benefits in checking disinformation, and may also be faulty. And the second is a much more public lecture we organized for Professor Apar Gupta from at Ashoka University, who did talk about encryption in the context of freedom, but much more in terms of what will be the political impacts around it. Finally, Ashwin, I remembered about the time from my childhood where there were certain export controls also, which prohibited the export of certain gaming consoles because of the processing power. When you mentioned Phil Zimmerman, how the US government prosecuted him for the export of the technology by itself. So governments all over the world have tried to control technologies, not only with respect to encryption, but also sometimes for Wolfenstein 3D. So and secondly, with respect to the edge cases which do occur sometimes, I'd just like to point out that there are other investigative tools and points of data capture which are possible beyond the envelope of the encryption which is afforded. And usually there are a whole range of investigative tools and techniques which go even beyond the technology apparatus by itself, usually to take into account these kind of instances. However, it does make me feel uncomfortable, and I would also like to acknowledge my privilege as a upper caste Hindu man when I have my own political lens towards encryption as a technology. This is not to say vulnerable groups do not benefit from it, but I would just like to acknowledge it into my own personal understanding about how the technology benefits society much more broadly.
Thank you so much, Apar and Ashwin. And thanks, Marisha, for that question. I'm glad that question did come up because it starts to raise a set of different questions. So, well, we could talk about this for quite a bit, but I think we should probably wrap up now. I do want to thank both of you for your time, for really sort of thinking through these problems and sharing some of this context with us. To the audience, thank you so much for being here. And I do hope you'll have time to come join us as we begin our 4th year of the Archives Public Lecture Series in March, next month, the middle of March. And we'll start off the 4th year by looking at design, the history of design, and do stay tuned for those details. But for now, thanks so much. And I think we'll stop the recording here, Pavitra.
Thanks.